Hello and welcome to Visa and Immigration Weekly, your essential explainer for the Bay Area's Indian community. Immigration alert for August 28, 2025. 3 major developments you need to track now. First, the administration is pushing to replace the H-1B lottery with a wage-based system, calling the current one a scam. Second, a massive new DHS proposal aims to end duration of status for students and eliminate the deference policy for visa extensions. And third, a local update. The Indian consulate in San Francisco has shifted most miscellaneous services to VFS Global. I'll break down what's proposed versus what's already changed and then give you specific time-sensitive steps to take this week, including how to comment on the DHS student rule, deadline September 27, 2025, and what to do now that the consulate's VFS change is already in effect, effective August 1, 2025. Let's break down our top story, the future of the H-1B. This week, Commerce Secretary Howard Lutnick, speaking for the Trump administration, sharpened the message on employment-based immigration, calling the current H-1B system a scam and pushing to replace the random lottery with a wage-weighted selection. In plain English, the higher the offered wage compared to the government prevailing wage for that job and location, a Department of Labor benchmark grouped into 4 wage levels based on experience, the better your odds relative to lower wage filings. This idea isn't new brand. The government previously floated versions of wage prioritization, but the renewed push, plus recent regulatory movement in Washington signals it's near the top of the agenda. The goal they cite is to favor higher-skilled, higher-paid roles and curb perceived abuse by low-wage outsourcing models. Why does this matter? For the Indian tech community, which historically receives the majority share of H-1Bs, the impact could be seismic. A wage-weighted system naturally advantages senior staff in high-compensation roles, major metros, and employers that can meet Level 3 and 4 prevailing wages, higher experience levels on the Department of Labor scale. Recent grads on OPT/STEM OPT, post-completion work authorization for F1 students, including a 24-month STEM extension, startups paying Level 1 and 2, and employers in lower-cost markets could see their selection odds fall. Expect compensation strategies to become central to H-1B planning and more scrutiny of how job titles, SOC codes, Standard Occupational Classification codes, locations, and wage levels align on the labor condition application. The LCA is the employer filing that attests to wages and work conditions. So, what should you do? First, this is a stated administration priority, but not a published regulation yet. The administration has signaled the change, and DHS/OIRA activity was reported in July 2025. The practical timeline to watch: if finalized, expect the first real impact no earlier than the fiscal year 2027 cap season, H-1B registrations that typically open in March 2026. Concrete actions now. Employers, run a Department of Labor wage level analysis for each H-1B role this quarter. Ask HR/Immigration Counsel to confirm the SOC code, the geographic wage zone, and the DOL wage level, levels 1 through 4. If you can legitimately pay level 3 or 4, document why. Experience required, education, supervisory duties, and be prepared to show that in the LCA and any I-129. Employees/candidates. Ask your employer for a written wage statement tied to the SOC code and work location. Collect supporting evidence now. Offer letters, job descriptions, recent W-2s/pay stubs if internal transfers, so you can prove the salary level if a wage-weighted selection system arrives. Timing and budgeting. Plan for March 2026 registration. Employers should set an internal deadline, December 2025 to January 2026, to finalize wage analyses, LC strategy, and a registration list so HR has time to certify LC details and prepare registrations. Startups and small employers, create a contingency plan. Either budget to raise wages for a small number of key hires, identify cap-exempt roles, universities, nonprofit research institutions, or evaluate alternative classifications, TN, E3, O1 where applicable. Everyone, consult an immigration attorney now to model scenarios for fiscal year 2026 registration if you will register in 2026 and fiscal year 2027 changes. Keep copies of job descriptions and wage documentation. If policy changes, these records will speed responses to requests for evidence.
Next, a massive proposed change that directly impacts every international student and, by extension, many future H-1B applicants who start in F-1 student status. The Department of Homeland Security has officially proposed ending duration of status for F, J, and I non-immigrants. For decades, F-1 students admitted in D/S, short for duration of status, could remain as long as they maintain status, full-time study, timely program updates, and proper OPT/CPT use without a fixed end date on the I-94, the arrival/departure record that shows your authorized stay. DHS now wants fixed admission periods, generally up to 4 years for F-1 and J-1, with extensions required if you need more time. For I-visas, foreign media, DHS is proposing an initial admission period of up to 240 days, with extensions of up to 240 days. Ending DS would be a fundamental shift. PhD timelines, major changes, co-ops, medical residencies, or leaves of absence could push students beyond the initial admission window. Instead of handling status primarily through your DSO, designated school official, and SEVIS, the Student and Exchange Visitor Information System, you'd need to file an extension of stay with USCIS, pay fees, and wait through processing queues, potentially with biometrics, fingerprint/photo, and RFEs, requests for evidence. If you change schools or programs, you'll need to watch both SEVIS updates and the I-94 end date. Your calendar becomes as important as your course load. Two big risks: administrative burden and delays. USCIS processing times could intersect with graduation/OPT start dates. And unlawful presence, meaning time in the U.S. after your authorized stay ends. Under DS, unlawful presence generally didn't accrue until a formal finding. With a fixed I-94 date, unlawful presence can accrue the day after expiration. Even short overstays can trigger 3 or 10-year bars. If finalized, set multiple reminders for 6 to 9 months before your end date, keep passports valid at least 6 months into the future, and talk with your DSO before any travel or program changes. Status check for Bay Area students. If this rule is finalized and you're on STEMOPT, you'd likely need a USCIS extension of stay if your I-94 expires mid-extension. J-1 physicians and scholars should map rotations against the fixed timeline, and I-visa reporters should plan assignments in 240-day blocks. Remember, this is a proposed rule, not yet in effect. The public comment window is open until September 27, 2025. Students in universities should submit comments via regulations.gov by the public deadline, September 27, 2025, and here's how to make those comments count. What to include: your enrollment level, program length, for example, multi-year PhD timelines, reliance on DS for OPT/STEMOPT transitions, specific harms, lost time, cost of USCIS filings, risk of unlawful presence, and suggested mitigations, longer maximum admission periods for multi-year programs, streamlined extension processes, fee waivers for student extensions. In the meantime, set calendar reminders, mark your current I-94 end date, and create alerts 9 and 6 months before it expires. Talk to your DSO now. Ask how your SEVIS record and I-94 might be affected, and whether your school will help with timely documentation. Financial and filing prep. Start budgeting for USCIS extension fees and potential biometrics if the rule requires filing with USCIS. Check with your DSO/attorney. The likely form would be Form I-539 or another DHS-specified extension filing. Keep passports valid for at least 6 to 12 months beyond anticipated dates. Travel caution. Avoid international travel close to any projected I-94 expiration without counsel. Re-entry may be riskier if a fixed admission period is used. Submit your comment. Search regulations.gov for the DHS proposed rule on duration of status. Use keywords DHS duration of status, FJI, and attach any personal or institutional examples. Universities should file institutional comments with enrollment data and program timelines. Now, buried inside that same massive DHS proposal is another critical change affecting H-1B and other temporary workers. The proposed elimination of deference for visa extensions. Here's the baseline today. In December 2024, DHS codified the long-standing practice of giving deference to prior approvals when the same parties and facts apply at 8 CFR 214.1C5.
That means if your H-1B role, employer, wage, and job duties are materially the same, an officer generally defers to the earlier approval, unless there's a material error, a material change, or new adverse information. Codifying this in regulation brought welcome predictability after years when deference had been rescinded and RFEs surged. What's new is that this proposal would formally eliminate the policy codified just last year. If this rule is finalized, deference would be gone. Extension filings could again feel like first-time cases, with more RFEs, longer processing times, and potentially higher denial risks, even when nothing important has changed. That complicates workforce planning for Bay Area employers and increases stress for long-tenured H-1B professionals and their families. Action items, practical checklist, and timing. File early. Aim to file H-1B extensions 120 to 180 days before the current H-1B end date. Earlier filing gives time to respond to RFEs without pushing employees into status gaps. Documentation to assemble now. Copy of prior I-129/I-799 approvals, the approved labor condition applications, recent payroll records last 3 to 6 months, employer support letters aligning duties to SOC codes, offer letter, and evidence the employee has been paid the required wage, pay stubs, W-2s. Put these files in an extension packet so HR/Immigration Counsel can quickly prepare filings. Prepare for RFEs. Have a plan and budget to respond. If deference is eliminated, adjudicators may treat extensions like new petitions and request detailed evidence. Premium processing. If timing is critical, budget for premium processing where available. Check current USCIS rules and fees at filing time. Green card strategy. Employers should prioritize filing PERM and I-140 where possible. For employees, if a PERM or I-140 has been pending for 365-plus days, you are typically eligible for one-year H-1B extensions under AC-21. Keep evidence of filing dates. If an I-140 is approved but your priority date is not current, you may be eligible for 3-year H-1B extensions. Check I-140 approval and current visa bulletin status. Monitor priority dates. Check the visa bulletin monthly and save your I-140 approval or priority date. Retaining that priority date is crucial. We'll monitor any formal moves to change deference and update you immediately. Finally, a practical local update for our Bay Area audience. The Consulate General of India in San Francisco has outsourced most miscellaneous and attestation services to VFS Global, effective August 1, 2025. VFS Global is the consulate's external service provider that manages application intake and logistics. The consulate still makes the final decision on your case. This includes services like power of attorney, document attestations, NRI certificates, and various certificates frequently used in property, banking, and family matters back in India. Routine passport, OCI, renunciation, and visa services were already with VFS. Now most attestation traffic routes there too. Certain limited services like life certificates and specific death-related documents remain at the consulate. What this means for you, step by step. Effective August 1, 2025, start every miscellaneous consular request on the VFS Global portal. Do not mail directly to the consulate. On the VFS site, select the San Francisco jurisdiction, download the exact checklist for your service, and book an appointment if required. The local VFS Intake Center address is 642 Harrison Street, Suite 200, San Francisco. Prepare documents exactly as the checklist requires. Notarized copies where specified, correct photo specifications, and any authentication, for example notarization or apostille, called for. Missing notarizations and improper photos are the top delays. Fees and payments. Pay VFS service fees and the consulate's ICWF or consular fees as instructed. Use tracked courier services and include a prepaid return envelope if you must mail a passport or originals. Timing. Check the VFS portal for current processing estimates and add buffer time if you need documents for a bank, property, or legal deadline in India. Submit earlier and consider express options where available. Proof and planning. Keep digital copies of everything you submit. Save booking confirmations and tracking numbers, and ask VFS for a receipt that shows when they received your application. So what should be on your radar? An immediate, dated checklist. By September 27, 2025, submit comments on the DHS proposed rule, duration of status, and deference. Use regulations.gov and include concrete personal or institutional examples.
October to December 2025, employers should complete internal wage level audits and decide which roles can justify level 3 or 4 wages. Set an internal deadline, December 2025, to finalize lists for potential H-1B registrations. January to March 2026, if the administration moves forward, expect H-1B registration activity and planning for the fiscal year 2027 cycle. Finalize LC and registration materials by January to February 2026, so registrations are ready for a March 2026 window. Ongoing now, students, talk to your DSO. Set I-94 reminder alerts 9 and 6 months before expiry, and budget for possible USCIS extension filings. H-1B holders collect extension documents and discuss I-140 filing to secure a priority date. Immediate step for everyone. Consult your school's international office or an immigration attorney this week to map your personalized plan and preserve options if these rules change. We'll keep tracking developments and flag any formal publications, comment responses, or filing deadline changes that affect your 2025 to 2026 planning. Thanks for watching Visa and Immigration Weekly. If you found this helpful, share it with a friend who's applying this cycle, and subscribe so you don't miss our alerts on the comment deadline, the H-1B publication, and any deference changes. We'll see you next week with the latest news and practical guidance to help you navigate your immigration journey. Have a good week.